Hey, good afternoon, everyone, and welcome to today's local government education program provided by the Illinois Association of County Board Members and the University of Illinois Extension. We very much appreciate this opportunity for programming collaboration in this most difficult time. My name is Kathy Brown, and I serve as the Community and Economic Development Educator for the University of Illinois Extension. For sound quality, we're going to be muting microphones throughout the presentation. If you do have problems connecting and those that have questions, please use the chat space to communicate that information. We're monitoring that, and we'll be able to pose comments or questions to our speakers at the end of the presentation today. Today's webinar is COVID-19 update, and it will be presented by Haya Roster, who are active legal partners for the Illinois Association of County Board Members. Our program is designed to provide local governments in Illinois information that you need to stay up to date with the legal challenges of the COVID-19 situation. Haya Roster legal partners will discuss the Family First Coronavirus Response Act, updates to the Freedom of Information Act, and Open Meetings Act, and the impacts on employment issues. Please note that a recording of this webinar will be made available on the University of Illinois Extension Local Government Education website and a YouTube channel. And participants will receive an email that includes the slides and links to resources and the recording for today's webinar. To get us started, I'm going to ask Kelly Murray, the Executive Director for the Illinois Association of County Board Members, to give us a brief welcome, and I will follow with introduction and a lineup for today's webinar. Kelly?
Oh, thank you, Kathy. Good afternoon, everyone. We appreciate your participation on this call today. I do want to begin by thanking our colleagues at the University of Illinois Extension for hosting this webinar. Our organization has partnered with Extension for many years in this capacity, and I think it's our intention to continue to conduct these informative sessions as the COVID-19 situation advances and kind of as the schedules permit. So hopefully we'll be working in partnership with you, University of Illinois Extension, on a few more webinars. As most of us are dealing with this unprecedented situation in our lifetimes, we know you as local government officials and community organizations have the added responsibility to protect and serve the public. But I want you to know, I know personally that Illinois has some of the most dedicated and qualified local officials at all levels, be it county, city, township. This is being proven daily. We're seeing it by our health departments, our law enforcement, our nursing homes, hospital personnel. You guys have shown great cooperation in the past in cases of emergency and natural disasters. We know we're in good hands with all of you at the helm. So again, I appreciate your participation today. We're here to be a resource and hopefully help you. We also realize you got to provide some continued guidance, I think, and support for your employees, in particular with the stay-at-home directive that's in place. It's a balance. It's going to be challenging. So today, I think as part of this presentation, that's why we're focusing on the federal employment law, Family First Coronavirus Response Act, and that became effective yesterday. Our speakers at Haya Roster are going to address this, and we really do believe it's important for you as employers to stay abreast of this new act as your employees continue to navigate from, the office to home and maybe also taking some leave. But before we get to our esteemed speakers at Haya Roster, I do want to introduce our legislative consultant, Taylor Anderson. He's going to update us on our ongoing communications that we are having with the governor's office as related to the federal coronavirus relief fund. You're hearing that it's referred to as the CARES Act, and kind of the process as we know it currently for the state and local allocations. Taylor, can you give us an update?
Yes, thanks, Kelly, and good afternoon, everyone. As Kelly mentioned, we've been in contact with the governor's office. The CARES Act that was signed by the federal government, or passed by the federal government, signed by the president, allocated about $150 billion to units of local governments across the nation. And Illinois is in line for, I believe, just just shy or just over $2 billion. Now, there are some provisions in the CARES Act which will divert money to, to local government that are over a certain threshold, 500,000 in population. And so some direct payments will be going to the largest communities in the state, but that still leaves about 45% of that allocation that Illinois is going to be receiving that the state can pass out to the various units of local government. And what we've been looking at and working with the governor's office and making suggestions on is that they allocate those dollars similar to how we allocate other dollars, state shared revenues on a per capita basis. We think that's probably going to be the most fair way to distribute those dollars. We know that regardless of the number of cases a community might have of COVID-19, the impact felt by the stay-at-home order, which has been extended now to the end of April, is going to affect units of local government bottom line via sales tax, others, and other methods. So it's critically important that we make sure that we get these federal dollars out to communities so that we don't see collapse at the local level. As Kelly said, we know you all on the front lines of this. You're dealing with this at the ground level, and it's important to make sure that we shore that up. So we're going to continue to work with the governor's office on that. We're going to continue to work with the governor's office as numbers start coming out on the budget. Obviously, the governor's budget address that he laid out in February has been drastically changed now because of this. And so as those things continue to, as those numbers and receipts continue to come in, we're going to continue to work with the governor's office and make sure we update you all as we get a better picture of what we're going to be looking like for FY21.
Okay, thank you, Taylor. Kathy, you want to go ahead then with the program?
Yes, thank you very much. We're really fortunate today that we have 4 representatives from the Ohio roster legal firm who, as I introduced before, are significant partners for the Illinois Association of County Governments. And so I'm gonna talk about each of the 4 presenters, and then I'll turn it over to the first presenter in the lineup. Andrew Keat serves as the chair for the Ohio roster Governmental Practice Unit. He advises public bodies in all areas such as litigation, risk management, contracting and procurement, employment, corporate governance, and sunshine laws. He will be discussing the impact of executive orders in his part of the presentation. Brian Smith will follow Andrew, and he's also a member of the Ohio roster firm, and he concentrates his practice in the areas of employment law, civil rights, education law, and commercial litigation. He is the chair of the firm's employment and labor practice, and he's going to be discussing Family First Coronavirus. Andrew is going to come back. Andrew Keat will come back, and we'll talk about guidance on what to ask and what not to ask employees. And then we're going to wrap up our presentation with a discussion led by Jessica Bell, who focuses her practice on the defense of insurance clients and employers in compensation matters. And she will focus her comments around workers' compensation issues. And with that, I'm going to turn it over with Andrew to start our conversation today. Thank you all for being a part of the program.
Okay, thank you. Well, as mentioned, my name's Andy Kite. I'm with the law firm Heil Royster, and with me today are Brian Smith and Jessica Bell. I have the position here to operate the PowerPoint. So if some point that doesn't work perfectly, that will be my fault. But I'm going to start off by talking about 2 of the governor's executive orders, and I'm going to spend about 5 to 10 minutes or so talking about those, and I'm going to turn it over to Brian. So the executive orders that we've had that have been most pertinent to us have been Executive Order number 2020-10 and 2020-07. If you're trying to locate those are on the governor's website. If you Google the governor's executive orders, it'll take you directly to the page. Just by way of clarification, the executive orders, they go by year, their numbering. So it's 2020-07 and 2020-10 are the executive orders, not to be confused with the COVID executive orders, which are numbered, their numbering is slightly off. So the COVID is, executive order number 8 is actually governor's executive order number 2020-10. The reason for that is there's been 2 executive orders prior to the whole COVID issue coming up. So with that, let's get into the details of the orders and how they're going to impact us and what we need to really be cognizant of as we go forward. Probably the one that we would start with, at least for these purposes, is Executive Order 2020-10. And 2020-10 talks about what is essential government functions. Unfortunately, of course, with any sort of order or law that's getting drafted in a pretty short order, it doesn't necessarily spell out everything we normally would or what the governor might normally do. So there's some open questions that are here, but I think we have, as a governmental body, probably enough guidance to steer us in the right direction. So first of all, as paragraph number 10 in Executive Order number 10 states, the purposes of the executive order: all first responders, emergency management personnel, emergency dispatchers, court personnel, law enforcement, corrections personnel, hazardous materials responders, child protection, welfare personnel, housing and shelter, military, and other governmental employees are considered essential government functions, along with those who are supporting essential business and operations. Those are exempt from Order 2020-10, which is essentially the stay-at-home order. The important part of this aspect for us is one of the obligations under the order is that as a governmental body, we're going to have to make a determination as to what the essential government functions are at this time. And we also need to determine of its employees, which ones and its contractors are essential to meeting those essential government functions. I've gotten a lot of questions on this particular issue. Most of the ones, smaller governmental bodies, probably most, if not all of your employees are essential government employees at this point. There may be, as you get into larger and larger counties, you may find that there are some employees that may not be essential at this point. However, I think most of the questions I've got are from the entities I've received. Typically, most of the employees would fit within the definition in some way of an essential governmental employee or a contractor. There may be some exceptions to that, but one of the things we have to do, the most important part of this, is we have to make those determinations in one way or another. Maybe it's from an order from the county board chair, could come from the state's attorney, but at some point we need to make some determination and put it in writing so that we have it, if in case that there are questions that come up later in time. So how do we make that determination? I think at a bare minimum, I think the obvious ones that are mentioned within the governor's order, which I'm just going to flip back to the slide that talks about that, all of those individuals that are in those governmental functions are certainly going to fall within that category. Once you get outside that category, of course, it's a very open interpretation, what we would consider supporting essential businesses and operations. I think almost all of the counties that are probably participating here, probably most of your employees are going to fall into the essential governmental employee category in some way or another. But we need to make some sort of determination, some sort of written determination is that we've done it to make sure we're in compliance with the order. All right, I'm gonna go on to the Freedom of Information Act and Open Meetings Act and how they've been impacted by the executive orders. Executive Order 2020-07, which under the governor's order is COVID Order number 5, but you'll find it as Executive Order 2020-07. And it expressly talks about the Open Meetings Act. It doesn't expressly talk about the Freedom of Information Act, but we've gotten some guidance. The Illinois Attorney General's office has put out guidance for compliance at this point in time, which is pretty helpful. And my understanding is there's going to be a follow-up presentation from their office, hopefully at some point in the near future about this issue too. But I'm going to touch on it nonetheless. The Open Meetings Act was specifically talked about in Section 6 of Executive Order 2020-07. And essentially what the governor's order does, it allows a suspension of the in-person meeting requirements of a governmental body. So most of you are probably familiar with this in some form or another, but the in-person requirements currently under the Open Meetings Act are, to paraphrase, they are, you need to have a quorum present, physically present for the meeting. Other people currently can do this electronically if they fall within a couple of categories. Either they're ill or they're unable to attend because a family member's ill or they have a work obligation. That was what the way the current version of the Open Meetings Act is written. The governor's order, which doesn't amend the law, so once this is over, we're going to go back, we will go back to the Open Meetings Act requirements as they're written now, but the governor's order suspends the requirement that you have a quorum present, and all members of a public body now then can appear electronically in some form. You could do it as a Zoom meeting, or you could do it telephonically. I've had a couple of meetings in the meantime since this has come out. All of them have been electronic in some way. Some have done them entirely electronically. Some have done them sort of partially electronically. In other words, we have some people present in a physical meeting space, and then everyone else on our board would attend by phone or by Zoom meeting some way. So, and that's okay under the governor's order, and we can proceed in that manner. A couple of questions that have come up that we've addressed. One is, typically under the Open Meetings Act, some people can mistake the 10-day notice requirement for a change in the regular meeting schedule. With, if we cancel a meeting, we have to give a 10-day notice, or if we change the meeting date, we have to give a 10-day notice. It's actually a little bit of a misnomer anyway, but what really is required is if you're changing all of the meeting dates, you have a 10-day notice requirement. Under the circumstances, we're not changing all of the meeting dates. If we're canceling a meeting, we don't have to do a 10-day notice. We just simply cancel the meeting and reschedule it for another time. The governor's executive order encourages meetings to be canceled if they're not necessary. But I think during this period of time, because of the length of time this is probably going to go on, we're certainly going to have some meetings at, I think most of our entities are going to have some meetings in some way. So the electronic attendance is probably the most common way. One of the inevitable questions that's going to come up with the change in the Open Meetings Act, or with the governor's order suspending some of the requirements, I should say. One of the inevitable questions is, how do we handle public participation? The governor's order doesn't expressly state that public participation is not allowed. It still is a requirement, but we can do so with some limited access as what normally would occur. So typically in a meeting, as you most know, members of the public are allowed to be in the meeting room where the meeting is taking place. And we can now allow for that to occur in a different manner. So if we're going to have a meeting, I think there's probably one of a couple different ways of context that'll go that we would allow public participation. If we have access to a big enough space and it can allow for enough social distancing for some members of the public to be there, you could have a public meeting in a physical space. probably the better recommendation, and the one I think most people are going with, is we'll have likely some members of the public body or of the board present, probably the person recording minutes probably be present, all while practicing, of course, social distancing, but that members of the public can call in through either a conference call. You could do a Zoom meeting, but those can, they all have a little bit of challenges to them. One is, how do you allow public comment in an organized way? And those are some of the challenges we're just going to have to work through. But if you're going to allow public to either monitor or participate in the meeting, such as in public comment, what we need to do is put on our notice how they're going to be allowed to participate in the meeting. Typically, that's going to come into the form of public comment. So the best way to do that is when you post the notice at whatever site, whatever location you're having the meeting, and on your website, you need to make sure that you have some allowances for how they're going to be able to participate. The most likely scenario is a phone call conference line so that people can participate in the meeting. Whether you do that public participation or public comment at the beginning of the meeting or at the end of the meeting, that part doesn't matter, but it allows to be compliant, A, with the Open Meetings Act and with the spirit of the governor's order, which isn't necessarily real clear on how the public participation would occur. Okay, let me touch on the Freedom of Information Act real quick before I turn it over to Brian. The Freedom of Information Act isn't expressly discussed, and there's no requirements in the Open Meetings Act, or excuse me, in the Freedom of Information Act that are suspended by any of the governor's orders. However, the Attorney General has issued some guidance on this, and a couple of things to keep in mind. Number one, when we're responding to a Freedom of Information Act request, there's a number of different reasons as to why we can extend the 5-day time frame to respond to a FOIA request. One of those, or some of those, would include the records are located off-site. Records are, we have to have somebody go track down the records. The employee responsible for the records we may be unduly burdening those individuals. Your FOIA officer may actually be at home during this time. And I don't think, I think in all reality, I don't think any court in likelihood will ding a public body for not being able to respond exactly within 5 days. However, we need to keep in mind that we want to try and remain as compliant as we can. So if you need to have extra time to respond, make sure you're follow up with them in writing within that 5-day time frame, or at least try to, and explain the circumstances and why it's going to take longer to obtain those records than normally the FOIA statute would require. The one aspect of this that I would also keep in mind is we can always mutually agree with a requester to extend the time frame to respond to a FOIA request. So I would certainly encourage that to occur. Certainly try and get those mutual agreements when you can. But I don't think either the Attorney General or a court is going to ding someone for not being able to respond within 5 days. I don't want to speak for them, but as long as we're making our efforts, reasonable efforts, to respond to the request and keep the requester informed during this time. So we will come back towards the end here with questions. I'm sure some people may have some questions about that, but to recap sort of those Open Meetings Act issues is, if you're going to do it electronically, the one thing I do want to make sure people are implementing is, if you're doing an electronic meeting or providing for an electronic meeting, that you're posting how the public can participate in that meeting on the agenda and on your website. Probably most of you have websites, but so if you have a website, make sure you're posting that on your website on how they can participate in whatever your next regularly scheduled meeting is, and also your social media sites. Okay. With that, I am going to turn it over to Brian, and I'm manning his slides remotely here, so hopefully I don't screw that up. And he's going to discuss the Families First Coronavirus Response Act.
Thanks, Andy. This is Brian Smith. I'm in the Champaign office of Heil Royster. Thank you for the invitation to be here today. Wanted to talk a little bit before we get started into the specifics about the FFCRA, just to kind of point out, I think, what everyone already knows, and that we are in a quickly changing environment. Guidance is being provided by the Department of Labor on a rapid rate. We continue to see new answers provided by the Department of Labor on their website, and new regulations and guidance being provided there. Last I looked, there were about 79 questions answered about the FFCRA. If you haven't had an opportunity to go onto their website and take a look at some of those, I would encourage you to do so. They're very helpful, and like I said, they're updating them daily as questions come in. So today, the two things that I really want to focus on with respect to this act are the Emergency Family and Medical Leave Expansion Act, as well as the Emergency Paid Sick Leave Act. First, talk about who does this apply to and when does it start. I've got a typo there. It actually starts on April 1st through December 31st of this year. But the key point being that this is going to apply to most all employers that employ 500 or less people. The question has come up a number of times. Does this apply to me? I'm a public entity. And if you have a specific question for your public entity about whether it applies or not, we can talk offline about that. But I've looked into it in depth for 2 clients, and the answer is a very clear yes, it does apply. And I think to most everyone on this call today, it's safe to assume that both acts do apply to you. Now, the Department of Labor announced just today that while enforcement of the FFCRA is not going to start until April 17th, that doesn't mean that employers are getting a pass to do, or violate the act for the next 16 days. Rather, they're going to retroactively start enforcement, but have communicated that they're going to give some grace if employers are making good faith efforts to comply. We can go back to one slide there, just a second there, Andy. Thanks. One other thing on this, with employers that are in the private sector, over 500 don't apply, and in some cases, small businesses with fewer than 500, or I'm sorry, fewer than 50 may qualify for an exemption. I'm not going to go into the specific elements of that exemption here because public entities aren't small businesses. However, for some of your constituents, to the extent that they need some guidance or interest, there again, I would point them to the Department of Labor's website. They have a 4 or 5-prong test about whether it would jeopardize the viability of their business as a going concern. Next slide. So in a nutshell, the FFCRA essentially is broken into 2 parts: emergency paid sick leave and emergency expansion of FMLA. The FMLA expansions here are significant in a couple of ways. The first is that this now applies to all employers. Previously, the FMLA only applied to employers who had 50 or more employees. So this is a new requirement for most. However, it isn't that significant when we really start and look at it in terms of what exactly is this new requirement asking employers to do. And really what it is asking employers to do is provide up to 12 weeks, 2 of them unpaid, 10 of them paid, for employees who are unable to work or telework due to a need to care for a son or daughter under 18 years of age because of school or child care provider closure. So immediately, if somebody is working remotely like I am right now, they would not qualify for this leave. I have 2 kids who in theory, are both doing e-learning at the moment. I have a daughter and a son. You can guess which of the two is probably doing it more diligently than the other. And if you're working from home and you're able to do that, the Act doesn't apply. So this is really for businesses where essential employees are to be physically present but can't because of school or daycare needs not being available. One other point on this, it talks about sons or daughters under the age of 18, but the Act is also very clear, and the guidance from the Department of Labor is also very clear, that if there is a dependent over the age of 18 that is incapable of self-care because of a mental or physical condition, that too is a qualifying event. Next slide. So you may remember for the FMLA that in order to qualify, you've had to have been working for a period of time. It has to be a number of hours, 1,250 hours worked. And the Emergency Expansion Act has done away with some of those eligibility requirements and shortened it significantly. And here shortened it to having worked for 30 days. And to be eligible, again, you have to have a bona fide need for childcare. And what is a bona fide need? Well, if in a situation where there's another parent in the house or guardian or some other daycare provider who can watch the children, then there is no bona fide need for FMLA expansion. And however, the Act and everything else that's been talking about this is encouraging people to, as much as possible, be flexible and be cooperative and generous with this time. Now, when it comes to how people are paid, the first 10 days are unpaid. However, as we're going to see in a little bit, under the Emergency Paid Sick Leave Act, you could use your Emergency Paid Sick Leave Act time for those first 2 weeks. So in reality, it can become 12 weeks of paid time off. Additionally, and this is something a lot of employees are probably going to want to do, is they're going to want to substitute unused vacation, personal, or sick time, because those typically pay at 100%. And as we'll see in a little bit, these acts, when people are staying home for their children, only pay 2/3 up to a cap of $200 a day. So I think it's quick to see that this Family and Medical Leave Expansion Act is going to be significant for a lot of people in our communities, a lot of people on this line, because we know for certain that school's not going to start until at least May 1. It's speculation to say what's going to happen beyond that, but I think most of us that have been talking about this anticipate that it's probably going to be longer. And so this will likely come into play. Next slide. Actually, can we go back one, Andy? I apologize. There we go. So when it comes to payment and how these are done, it works like this. The first 2 weeks under the FMLA expansion are unpaid, unless you use your paid sick leave or unless you use your accrued time. After that, you get 2/3 of your regular pay, up to $200 a day, with an aggregate of $10,000. Now, the actual aggregate would be $12,000 if you include both acts, but that is the total amount that can be paid. Part-time employees are also eligible for leave. However, that's going to be based on the average amount of work that they normally did before they took the leave. And so you can calculate that based on past practices and past payrolls. Next slide. So if somebody does take leave, the Act, just like the FMLA, provides for job protection if they take leave for a qualifying reason. And one of those things, again, that the Congress and President recognized is that this is new for employers under 50. And so for people who employ 25 or fewer, they don't necessarily have to restore their employees to the same or equivalent position, assuming that these 4 conditions, which are on your screen here, are met. Next slide. Moving on briefly to the Emergency Paid Sick Leave Act. This is a much more straightforward analysis because it essentially says if you have one of 6 different categories of issues, and we'll address in a moment, you're entitled to 80 hours of paid sick leave if you're unable to work. That doesn't matter if you're able to be present or if you're teleworking. If you are dealing with COVID-19 related issues, then you get paid for your time off. Again, part-timers are also eligible for this. Now, before we go on, there are 2 things I wanted to mention as far as exemptions to this act. The first are healthcare providers. Healthcare providers don't have to follow either the Emergency Paid Sick Leave Act or the FMLA expansion. Another one particularly important to public entities is emergency responders can also be exempted out of this. And emergency responders include law enforcement officers, correctional officers, firefighters, EMTs, so on and so forth. Next slide. One of the key differences between the Emergency Paid Sick Leave Act and the FMLA expansion is that you can use this immediately. There is no certain number of days, weeks, or months that you've had to have been employed before you can take this leave. Unfortunately, I think in the environment that we're in, the immediacy of the use is probably not all that germane, only because I don't think very many people are hiring right now. But if somebody was hired on and then they got sick or they needed to be quarantined, they would be immediately eligible for the emergency sick paid leave. Next slide. So I mentioned that there are 6 categories of qualifying uses for the emergency paid sick leave. I want to walk through these and how an employee is paid depending on which category qualifies in their situation. So the first of these categories is if the employee is unable to work because they're subject to a federal, state, or local quarantine or isolation order related to COVID-19. And we have received many calls and questions about that specific section. Does Governor Pritzker's stay at home, shelter in place order qualify as a state quarantine or isolation order? And the short answer that we've received from the DOL based on their questions to answers posed is no, it does not. That is certainly subject to change. I could log off of this Zoom and there could be new guidance on that subject, but the quarantine and isolation have different meanings than the shelter at home. And in addition to that, the governor's order was issued before the acts in question here came into effect. The second reason is that the employee has been advised by a healthcare provider to self-quarantine. And the third is the employee is experiencing symptoms of COVID-19 and seeking medical diagnosis, which is significant. It's not enough to have a dry cough. You need to have a dry cough and be seeking a diagnosis that you do or don't have COVID. Next slide. So under these circumstances, if you have a qualifying use in one of these first 3 categories, the paid sick leave that you're entitled to is your full salary or wage rate, subject to the caps of $511 a day or a maximum of $110 for 10 days of paid sick leave. Next slide. I think we might have gone too far. Let me back up one, Andy. There we go. So the first three categories provide you full pay, subject to the caps. The next three categories, employees only paid 2/3 of their regular salary, up to a $200 a day cap and a $2,000 aggregate over the 2-week period. And those qualifying uses are if the employee is caring for a family member who is subject to a quarantine or isolation or has been told by a doctor or healthcare provider to self-quarantine. If they're caring for a child due to COVID-19 because their kid's school or child care provider is closed. So here, this is the one that we're going to see the most, I think, and this is what dovetails with the Family Leave Act expansion. And this is where you can get those 2 first weeks paid at 2/3, and then you can go into your 10 weeks of paid under the FMLA. And then the last category is a catch-all of experiencing any other substantially similar conditions. We don't have a lot of guidance on what that means. I think, again, it's intended to be a catch-all and will be a case-by-case analysis as to whether it applies. Next slide. I think everyone by now has probably already posted a link to the FFCRA poster and maybe even requested a physical copy of one for the Department of Labor. If you've not done so, please go to their website. They have a PDF that you can download and email to your employees, and you can post on your websites. In addition, you can contact them directly and they will mail you a physical copy that you can put in a conspicuous place on your premises. So what is prohibited by the FFCRA? It's very similar to the ADA or the FMLA, and that is if somebody exercises their rights under these acts, you're not allowed to discharge, discipline, or discriminate against them for having taken that leave, or prohibit them from filing a complaint for you as the employer not following the proper procedure. And while somebody is on paid sick leave, they do have job protection. They should be, to the extent possible, returned to the same or equivalent position upon their return. Next slide. Now, one thing that I wanted to touch base on here is that with the CARES Act, the private employers are promised to be repaid by the federal government for expenses incurred under either of the paid leave or the FMLA leave. It's not clear whether that is going to be amended or whether new legislation is going to be passed that would provide for that. But at this point, there is no tax credit for public employers. With that, I will hand it over to Andy.
Okay, thanks, Brian. I've in the chat space on this meeting, I've tried to keep up with the questions, and we're going to try and leave time for some questions too. And I know we're about got about 15 minutes to go. I'm probably going to skip over some of the slides. The information is still there for the most part, and I'm going to kind of cover them for the most part as we go through. One thing I wanted to touch on is signage within our space, our governmental bodies. So not only in addition to the Department of Labor's required posting under the FFCRA, we also have some suggestions from the CDC as to posters we may want to put in place. And they've actually put up on their website, the cdc.gov website, flyers for recommended signage in your space. You can come up with your own, but it's much easier to just go print it off the CDC website. It's everything from, social distancing, washing your hands, sort of guidance on those types of things that you can put up in your restrooms, common spaces, things of that nature, but also, such things as what symptoms you might be experiencing that might be related to COVID-19. So that your employees are aware that you can put up in your common spaces too. So with that, let's talk about some of the dovetailing that goes on between ADA and EEOC issues that might arise with trying to manage this issue within our office and keep a safe workspace. I'm going to skip ahead a little bit, and we're going to talk more about what you can and can't ask an employee at this time. We've luckily gotten some guidance from the EEOC, and very importantly for our needs, the CDC in March of 2020 indicated that COVID-19 is a direct threat, meaning a significant risk of substantial harm that cannot be solved by reasonable accommodation. That's an important aspect. If we have someone off work because they have a COVID-19 diagnosis or experiencing symptoms, we may not be able to reasonably accommodate them at this time. Now, what can we ask employees and what should we not ask employees in order to maintain a safe workspace? Because this part really kind of gets down to sort of the how do we make sure that we're keeping a safe workspace for our employees. So the very first one, I think probably the most common issue is whether can we even ask employees if they're experiencing symptoms that might be related to COVID-19. For example, are you having a fever? Do you have chills, cough, shortness of breath? Apparently, if you've lost your sense of taste or smell, do you have a sore throat? Those are all questions normally we wouldn't go around asking employees, right? But at this point in time, the current guidance is we are able to ask our employees that. Can we ask then if an employee is experiencing symptoms that might be related to COVID-19, can we ask them to work from home or leave the workplace if we have to? We can. We can do that at this point in time in order to maintain a reasonably safe workspace. Can we ask employees or mandate employees to tell us that they have obtained a positive diagnosis of COVID-19? And we can do that. That's of course going to kick in some of the obligations that we may have under the FFCRA or emergency paid leave that may come up. But we can ask our employees to tell us or mandate to tell us if they've had a positive diagnosis. Inevitably, what's happened, I've had this situation has come up, of course. What if we have an employee who has tested positive? Well, of course, we do have the issues that relate to that employee needs to stay home. If they can telework, if their symptoms are minor, they can do so if they want to, you know. But what do we do in two aspects? And this, I've had to deal with this issue as well. Number one is, what do we need before that employee can come back to work? Number one. Number two, what do we tell our other employees? So the first question is, what do we need from that employee before they can come back to work? And I think the best recommendation right now is that they have a note from their treating physician that they're no longer contagious and they're able to return to work. I think that's probably the most prudent course. We can require a doctor's note. If they've not tested positive for COVID-19, in other words, they went home with symptoms and they were tested, but it was negative, I don't think we can require them to return with a doctor's note in order to return back to work. But if they are positive, I think you can have them return with a doctor's note. Then inevitably the question becomes, what can we tell our other employees? Because inevitably what has occurred is other employees within that, within the county or township, whatever governmental body you are, other employees are going to have questions. The likelihood is the identity of the person that's been diagnosed is probably already known. However, we cannot identify who that employee is. We have to be very vigilant in in keeping their information confidential. We have to be very vigilant in making sure that their identity remains confidential. The reality is, other employees are probably going to find out the name of that person, but we need to be careful as the employer not to reveal the name of that person. What should we tell employees? One of the, I think the best guidance out there right now is making sure that any employee someone who had a positive diagnosis, any employee that they came into contact with or had close proximity with, those employees should probably go home. Unknown, of course, if they are COVID-19 positive or did get it, but they may not be experiencing symptoms, but they may have it. So probably the most prudent course is to have them go home as well. The question sometimes has arisen of, well, what should we do? And the question to make sure that we're keeping a safe workplace if someone tested positive for COVID-19. And I think probably the best thing and the most prudent course to make sure that we're protecting our workspace then is to work with your public health department and make sure that you're following their recommendations. If they're recommending, deep cleaning, there are some entities out there that are able to come in and do a deep cleaning of the space. Generally, you may require someone who's come into contact with a COVID-19 patient to tell you. So if someone has come into contact that they know of, maybe it's a friend, relative, maybe it's a parent, could be anyone. But we can require employees to tell us if they've come into contact with someone positive of COVID-19. We can also require employees to tell us if they've had, if they've traveled to an affected workspace. Can you take employees' temperatures? Yes, we can. Considered a medical exam, but you can take employees' temperatures. You need to make sure that you're keeping the information from taking those tests confidential. Those things are considered medical examinations, and we have obligations to keep that information separate and confidential. If an employee has traveled, I think I covered this, you can ask them to tell us if they've been to an affected area. All right, what should you not ask? You can ask employees about their medical conditions, but you cannot ask the employees about their medical conditions if they don't have any symptoms related to COVID-19. In other words, this isn't an open door to go in and ask about every medical condition someone may have. It needs to be tightly contained to the COVID-19 issues. I think there's a sort of a general knowledge of what those are right now, but mostly fever, cough, chills, sore throat, things of that nature. Don't wade into areas that are not covered or not considered COVID-19 symptoms. You can require telework. You can require hand washing. You can require personal protective equipment. You cannot require vaccines. There isn't one yet, of course, but one might become available at some point in time. You cannot require vaccines. You should continue providing reasonable accommodations, even for work at home if you can, but most of the reasonable accommodation requirements related to COVID-19. In other words, if you have an employee who has been positive for COVID-19, right now the reasonable accommodation standards a little bit tightened. But if you have employees who otherwise you would have to give a reasonable accommodation to, you need to work to do that, even if it's at their home. Enforcement is going to be by the EEOC and the Illinois Department of Human Rights. You may see some enforcement actions from the Department of Labor, but probably most of them will come from those two entities. Before we move on to workers' compensation, any information and records you gather related to COVID-19 and specific employees needs to be kept separate from the regular employment file. So you have a regular employment file, you all should, regarding each of your employees. Anything related to COVID-19 and your specific employees needs to be kept separate. With that, I'm going to turn it over to Jessica, who's going to talk about some workers' compensation issues.
Hi. So I only have a few minutes, which was kind of by design, but it does seem relevant to talk about if we're talking about how to keep the workspaces safe and how to handle if somebody comes in and has tested positive or has symptoms, to address the possibility of could they possibly have a workers' compensation claim and what would they need to establish. And I'm going to admit that I had a client ask me a couple months ago, before things really kind of blew up here, what do I do if somebody has a claim? Do you think it's valid? And I naively said no. There's no difference here between this and the flu. There's no increased risk to anybody. And I said that you should definitely deny that. Fast forward to our current situation, and I would say things are a little bit different now. I think now you can certainly establish possible exposure. You might be able to address whether or not somebody had exposure at the workplace, and what do we have to do here? So even though there have been some changes and modifications to some of the laws that Andy and Brian talked about, there has been no change to any workers' compensation. There's been no temporary enactments of anything. Nothing has changed. So we have to keep in mind that the employee still has to prove a claim, and there are standards for infectious disease contraction and workers' compensation. What they would have to prove is either direct contact or that their job significantly increased their potential exposure as opposed to their outside activities. So what's interesting is that, a couple months ago, I think we would have had a hard time establishing that work significantly increased their exposure. But now things have changed, and with so many businesses shutting down unless you fall under the essential, unless you're providing an essential function, you might be able to now establish that somebody did have increased exposure because of their job. So if their job does not allow them to telework and they're there at their place of employment and they have exposure to the general public, such as we can all think of, grocery employees, obviously anybody in the medical profession, but really, if you looked at the list of essential employers, it's pretty widespread. So there are a lot of businesses that would fall into this. Certainly, a lot of the people listening today are essential functions. And if you're working and you're not able to follow the social distancing guidelines, so you have that increased risk of exposure, you could have a claim could have a workers' compensation claim. Because there have been no changes or modifications to the laws for workers' compensation, we do have a couple of cases that are relevant that we could talk about. Just going to very briefly mention them as they might provide some example of what you'd be looking for here. So one of the cases is, Andy, can you switch slides, please? One of the cases is Smith versus Methodist Medical Center. An administrative assistant contracted MRSA. She was an administrative assistant in a hospital. And this can be similar to our current situation because her claim was denied because the particular strand of MRSA that she contracted is one that is also found out in the community, and evidence that the employer had gathered once they learned of her condition was that she had been out at a large community gathering just before she contracted it, and she was not able to prove that her employment was the link to contracting that disease. So obviously, in the current climate where we're quarantined, for lack of a better word, we're social distancing, we're working from home, and we know that this can be contracted in the community, you can take that case to consider. It might be hard to establish a link between work and COVID-19. The second case that I wanted to mention is Sperling versus the Industrial Commission. In this case, we had a nurse who contracted hepatitis B. And on the front end, you might think, well, it's a nurse, and obviously she has greater exposure to medical conditions, so she might be able to establish causation there. She wasn't able to in this case, and that's because even though she was able to provide evidence that she does have a greater chance of pricking herself with a needle because of her profession, there was no actual evidence that hepatitis B was present at her place of employment at the time that she contracted the disease. So just because there might be a greater risk of contracting it, you still have to establish that you could contract it, that there was somebody there to contract it that had it. So in this case, or in the case of COVID-19, you're going to want to think about the fact that if work does not allow for social distancing, if you do not allow people to work remotely and you have that same exposure to the general public, you certainly could have an increased risk of contracting the disease, which in the case of somebody that does contract it, they could have a valid workers' compensation case. Now, another thing to keep in mind, and then I'm done, is that at the end of this, at the end of the day, workers' compensation is concerned with permanency for the most part. Yes, if somebody has a valid claim, you would pay their medical bills and you would pay any time off work, which appears to vary based on their recovery. But at the end of the day, it also depends on permanency, and permanency has to deal with what residual issues do they have. And I think what works in our favor as employers is that unless somebody dies, most people are experiencing a full recovery. Arguably, if there's a full recovery, there's no permanency. So even if somebody is able to establish that they have the condition, that they contracted the condition based on their employment, they have to still establish permanency. They would have to either, unfortunately, pass away, or they would have to show some permanent other condition, such as a diminished lung capacity that's not going to resolve, or something like that, in order to have a claim for benefits. So I think it's important to keep in mind the things that Andy said in terms of keeping your workplace safe if you do know of somebody that has it, because you could be opening yourself up to a workers' compensation case if there is any evidence that somebody there has it. That's all for me.
Okay. Excellent. So I've tried to keep up with the questions in the chat space at the same time here, and I'm hopefully I'm somewhat keeping up. I don't know if the moderator has any comments as we close, or if we want to continue. Maybe we could take questions. I can try and answer them as they come up.
Let me do a couple of things. So we can try to capture all of the written responses that you've keyed in and make that part of the email that will go out to participants following this webinar. So let's just kind of scroll real quickly and make sure if there are any pending questions that haven't been responded to. Yeah, so we'll work on sending the questions and the answers in sequence along with the PowerPoint out. So I'm just going to start at the bottom and work my way back up really quickly. And if the appropriate speaker can respond to this. One of the questions was, can we ask an employee to use sick days? We were willing to pay him at his regular rate to stay home. Can we request that they use their sick days?
So this is Brian Smith. I think that question is in response to somebody who went to Mexico and then was requested to self-isolate by their employer, and then was seen out in the community. And I think in that situation, the CDC or the federal government and the state of Illinois aren't requiring people coming from Mexico to self-quarantine, with any sort of teeth to it. I think that what the employer can do is say, we don't want you coming into our workspace any longer because you've been exposed, potentially. And when you're in Mexico and we want you to stay for 14 days. I honestly am under one of those right now. I was in Peru and had to get a repatriation flight for my family, and I had to get home. And that's why I'm not in the office and I'm here. However, I think that my employer can only require me, or in your case, to do that with respect to not going into my workplace. So I don't think that you could legitimately require them to burn sick time because they went to Walmart, unless you're going to require everyone that's in your employ that goes outside of their four walls of their house to use sick time and self-quarantine.
Thanks, Brian. There's a question in here that is asking about annual town meetings that are scheduled. Can someone respond to that?
Yeah, this is Andy. I can respond to that. My understanding right now is the annual town meeting, which I think is scheduled for the 14th, I believe. That required annual town meeting hasn't been suspended yet. However, my understanding is there are some efforts underway to get that either the date changed or to get some special rules in regarding to the annual town meeting for the governor. Right now it hasn't been suspended, but it's something that's being monitored pretty closely. It's something being monitored very closely.
This is Taylor Anderson. Can I cut in real quick?
Sure, that'd be good.
Yeah, so Taylor Anderson, I, along with lobbying for the Illinois Association of County Board Members, also lobby for township officials of Illinois. So we have been working, TOI has been working with the governor's office to address that concern. We are anticipating a resolution either later today or possibly tomorrow.
Perfect.
Thanks, Taylor.
Thanks, Taylor.
Yeah, so there is a question about personnel file guidelines, which they're asking if you would have a regular personnel file, a medical file, and then a COVID file.
I would have a separate COVID file. 100%, yep.
Thank you. Should all governments enact the FFCRA now, even though they are continuing to pay salaries so far?
This is Brian. I can take that one. So, I mean, obviously, your entity is subject to the FFCRA right now, whether you enact it or not. I think that the question is perhaps getting at whether you should continue to pay your employees or whether you should consider them being placed on leave pursuant to one of the acts. And I think that the only way that the acts will apply would be if one of, well, in the case of the FMLA expansion, that they were staying home with a child, in the paid sick leave situation would be if one of those 6 qualifying events took place. And so I don't think that unless you have something that qualifies, that there would be any impact on what you're doing right now.
This one kind of dovetails in there as well. Do employees have to file for these measures at this time the county board is agreeing to continue to pay salaries? So is it up to the employee to file?
Absolutely. And the DOL is encouraging people to be as generous as you can. You know, I think that the hope is that we get through this sooner than later. But if you're agreeing to pay your employees, they don't need to seek leave under the act. But if there is a situation where an employee needs time off for one of the reasons set in the act, they do need to communicate with you in the same way that they would if they were taking a sick day, or in the case of the FMLA certification that their daycare is closed or their school is closed.
We have a couple of questions regarding a normal work week is 35 hours. So is it 12 weeks at 35 a work week or 40? And then from the same person, they're saying that they're a little confused about the 2-week paid or unpaid. If an employee has children and school is closed and a babysitter will not keep the child because of COVID, do they get the first 2 weeks unpaid or paid?
So I think I tried to answer this one in the writing. I don't know the answer to the 35 versus 40. Most likely it's going to turn on how you typically pay your employees. But again, I don't know that for certain. With respect to the unpaid versus paid, so if they are taking leave under the emergency FMLA expansion, the first 2 weeks are unpaid. However, you can fill that gap of that unpaid time in one of two ways. They could take accrued time off, whether it's PTO, sick time, vacation time, and get paid their full salary, or they can use their emergency paid sick leave time, which would pay them 2/3 of their salary.
Does that cover the questions about paying 10 weeks, even though school is technically out for the summer by June 1st?
Yeah, that's a good question. I think that I have not seen any specific guidance on that question. However, indirectly, we've seen direct guidance on that, and that indirect guidance that we've seen says you have to have some sort of proof that your school is in fact closed. So I think once the school year is over, I think that the ISB probably is figuring this out now, what they're going to do and how that's going to work. The school year may well be extended. But assuming that it is over, I don't think you're going to have to pay that. However, you probably will still have to pay the same way, because it's not only schools, but also childcare. And so if this, summer's here and they don't have a place to go, whether it's a day camp or a nanny or whatever else, then they would still be able to apply those acts.
So a couple of questions around, how to do meetings. Would a quorum of a quorum be enough to proceed in holding your public meet or your township or council meetings?
This is Andy. I can answer that one, and there is another Open Meetings Act question that I have up here too that I'll answer as well.
Okay, thank you.
The governor's order only suspends the requirement of in-person attendance. It doesn't suspend the requirements of a quorum. So we need to have a quorum, whether that's physically present or by phone or Zoom conference, however you want to do it. So we still would have to have a quorum of people or a quorum of our public body in order to be able to conduct business and pass resolutions and ordinances and do everything that we would normally be doing. But they can all attend electronically. This dovetails with another question that Megan had, and her question was with the exemption to the Open Meetings Act allowing virtual meetings. She has 3 questions. One is, does anyone need to be physically present for the meeting, or can everyone be remote? It's not required that anyone be physically present. My strong suggestion, though, is that you do have probably some of the board members. It doesn't have to be the quorum, but you need to have, I would suggest, having some of the board members and whoever is taking minutes be present in one room. You're going to practice social distancing and all those good things as well. But it's not required, but that's what I would strongly suggest, just for the organization of the meeting itself. And then everyone else can attend electronically, including other board members. Members of the public can attend electronically. It's going to be really difficult, I think, for a lot of governmental bodies that don't have big meeting spaces available to be able to accommodate a large crowd or a crowd of any size. So I would encourage that it be public attending by phone or Zoom meeting. Second part of her question is, does a previous ordinance need to be in place to allow virtual participation, or does this temporary exception to the act allow for it regardless of the ordinance? So the governor's suspension of the requirement doesn't require us to have a prior ordinance in place. Most of you are probably aware that if you're going to allow electronic attendance because someone is ill or caring for someone ill or has a work obligation under the Open Meetings Act, that you need to have an ordinance in place allowing for that and how it's to occur. The governor's order, though, doesn't state that you have to have that as a condition precedent under these circumstances. So You don't have to have a current ordinance dealing with it to allow for electronic attendance. Third question in regards to the notification, what if the notice was published in the newspaper? Is notification of the virtual meeting, hold on, I gotta see the rest of the question. In regards to the notification, what if the notice was published in the newspaper? Is notification of the virtual meeting sufficient on the website and a posted agenda, or do we need to post in the paper that the public can dial into the meeting? There's not a requirement in the Open Meetings Act that you do publish in a paper. You probably are publishing in the newspaper at the beginning of your year your listing of when your regular meetings are going to be. If you are posting in the paper all of your regular agendas every time, then yes, I would suggest you post how they can participate there as well, but that's not required that you post in the paper. I would post it on I would put it on your agenda that is posted at the meeting site. I would put it on your website as well, and any social media that you may have, how people may participate in the meeting.
Andy, I think these are yours too. Early in the chat space, there was a question about the executive order, and does it state that a formal written determination of who is deemed essential need to be completed? And they were also asking about functions like assessment and zoning to be considered essential or non-essential.
Yeah, and
Did you respond to that one?
I did, but I'll say it so that the rest can hear it too. So I don't, there is no requirement that the determinations of what essential functions of the government are and who the essential employees are at this time, it's not required that it be in writing. It's probably a best practice just so that you have it memorialized somewhere. Again, with probably the majority of governmental bodies, you're probably going to have a determination that either all employees or the vast majority are essential because they're doing some role related to one of those delineated items in paragraph 10 of Executive Order 2020-10, or they're supporting essential business in some way. The second part of that question, which I think was about whether people in, I think economic development or zoning, if they would be considered essential. You know, that's a case-by-case basis. So, you know, I don't see that there would be anything wrong with designating them either way. I know it's not accounted for, or a little bit of an unprecedented arena that, but it's not specifically delineated out in the governor's order. However, I can certainly see arguments either way, and I don't think you're going to have, you know, much backlash either way if you determine based on your determination. It could be that, you know, if you don't have any zoning applications going on right now, then maybe they're not essential. But I can certainly see how supporting essential business, you know, a zoning office, for example, could be considered a essential part of the governmental function right now, for sure. And, you know, building code inspections and things like that might be going through building and planning, or I think those are probably all would still be considered essential business as well. So I think there's arguments both ways. I think the important part is to make some determination that you memorialize somewhere.
Can you speak to, towards the end of the questions, they were kind of asking what triggers that written determination of essential in government? Is that a request of the state's attorney, or how do they trigger that?
Oh, how to go about it, you mean?
Yeah, right.
Yeah, so, you know, good question. Depending on your form of government, whether, you know, you might be a township, you might be, you know, there's various different types of a county, could be a municipality. You know, depending on the form, there's probably someone we would consider to be the chief executive officer, whether that's county board chair, whether that is, you know, the mayor of a city or the supervisor of a township. It probably should come from them with advice and consent of the departments of their governmental body. That's probably the best way to do it. I would, as with all of any question that is, you know, specific specific in nature. If you're a county, you have your state's attorney, and if the state's attorney wants to send you on to us, that's fine. But you typically the first line of a specific type question will go to your state's attorney and have him or her funnel it to the appropriate person. I think the best practice right now is that the chief, who we would consider in whatever governmental form we have, whoever we would consider the chief executive officer should be the one making that determination, with advice and consent from the department heads.
So there's an Open Meetings Act question from townships. Andy, did you see that? So they met by teleconference, but it was recorded, and they're saying that the recording is only being made by a FOIA request. Does that meet the AG directive, or what kind of recourse does the public have?
I'm not quite sure what that question is, but it sounds like they recorded a meeting. It sounds like the township had a recording of the open session of their meeting, and someone's requesting it by a FOIA request. If that's the case, then it would be disclosable because it's considered a governmental record. I mean, it's of open session anyway, so I would just disclose that.
Very good. Can you require proof from an employee who claims they need to be off work quarantine because their mother was possibly exposed or having symptoms, taking care of their mother?
I was searching through for the answer to that as Andy was talking. I don't know the answer. I know under the FMLA, you can get certification that you need to take care of your child. I think under the specific fact scenario that was provided there, I'm not 100% sure that employee would qualify if they just think they were exposed and they're not showing any symptoms, and they're not seeking medical diagnosis, then I don't think it would be a qualifying event. But assuming that they are showing signs and that they are also seeking medical advice, then I think I would err on the side of giving it to them. But I think being able to require some evidence that they're not just trying to take time off, which I assume is the concern of this question, is most likely going to be considered legitimate.
The question, do we have to allow abstractors and real estate people in if the courthouse is closed to the public? And can we set rules and hours for them?
I think this is Andy. I'll probably take that one. Do we have to allow them in? So a number of the circuits have been making their own rules. They're allowed to do so. Some of the courthouses are closed entirely. I think I would leave this up to the chief judge as to whether or not to close the courthouse in its entirety. If you do have it open, you can certainly make rules as to access. It could be probably a reasonable restriction if you're going to do so would be to only allow certain numbers of people into the recorder's office at a time, or abstractors in at a time. It could be one at a time even, but you could require certain rules in order to reduce the chances of infection.
Does that get complicated when you're talking about essential businesses? So you've got essential businesses that need that information. So
yeah, I do think that essential businesses. The essential businesses under the governor's order is pretty broad, and I think those entities are considered essential businesses. But of course, the governor's order doesn't discuss how the essential business might dovetail with another. For example, governmental body. So I think your probably best case scenario is to create rules limiting the access to either certain hours or for sure limiting the number of people that can be allowed.
Yeah, I was thinking about agriculture. So Department of Labor has posed some exceptions to the Family First Act, and one of them is that it creates a hardship on the business. Does that pertain to government?
This is Brian. I do not believe it does. I think that is only for private employers.
There was one question clarifying the recording question, and the question is clarifying the township question and the FOIA request. It looks like in that question, they're saying that the township recording question is that the meeting was only attended by board and the recording is only available by FOIA request. This does not seem in accordance with the AG directive to post the recording as soon as possible. Yeah, I mean, if you have a recording, I would make it available for sure.
I think that's it. There is a question about railroad benefits, and I'm not sure how that fits within our discussion today. That seems like
Actually, I answered in the chat to Derek about it, but I can just note very briefly. First of all, I don't practice railroad work, but the difference, he was asking about the difference between railroad and the workers' compensation laws, and basically workers' comp is a no-fault system. So for us, you don't have to prove anything. Under FFCRA, where a railroad employee would file a claim, they would have to establish some sort of negligence on the part of the railroad to get benefits. And it can be even just minimal, but they have to establish some sort of negligence. In this case of COVID-19, I would assume that negligence would be some of the things that maybe Andy talked about for, keeping the workplace clean and safe, and getting somebody out of the workplace once you know that they have a diagnosis, things like that. So the difference is they have to establish some sort of negligence.
Thank you. I missed the response to that. We have just a couple more, I think, that we haven't responded to. So we've got a newspaper publication that's asking, they've already posted notice in their paper, and now they're changing it. Do they need to publish an update in the paper notifying the public to dial in remotely?
Okay, so if you have time to do so, I think your best practice under the guidance from the Attorney General, and the best practice I think in general is if you have time to post the information for the public to call in, I think it's probably prudent to do so. If I would also make that change on your public posting at the site of the meeting and on any social media or any website that you have. But if you don't have time to get in the paper, I think you'll be okay making sure that you post it on your social media, your website, and posting it where the meeting is taking place as to how the public may participate.
Right behind that is a question about denying public to be physically present at a public meeting.
Okay, so I think I see that one from Tim. If a member of the public, give me one sec, I have something else pop up on our screen. If a member of the public were to physically present themselves at the public meeting, can they be denied access? Assume there's no indication they have COVID. Can the public meeting be held in the city administrator's office or in its regular location? So first part of that question is, can a member of the public be denied from entering the meeting? If you're having some physical presence of a meeting, you can do that. I would strongly suggest that if someone shows up, then this is another reason why I think it would be prudent to have electronic attendance being allowed in some way and informed on your posting. If they do show up, I would, if you have a space to put them in a different room, you can, connect them up to the phone line. Otherwise, I would tell them at this point in time, under the current situations and in compliance with the governor's order, we're not allowing anyone from the public into the actual meeting, but we are allowing people to attend electronically. And if you have public comment or issues you're wanting to raise during public comment, you can do so, and we will still ask for public comment. I think that's probably the best way to do it. That way you're still accommodating the public, but also making sure that you're keeping social distances and those kinds of things. I think the second part of the question is, can the public meeting be held in the city administrator's office rather than its regular location? As long as you can have, as long as you can have social distancing in that office, I think you're probably okay with that. That's fine, as long as you know, your people are able to participate, board members are able to participate by phone, and you have enough space to keep people distanced at that point. Yeah.
I think this is our last one. I hope I haven't missed any, and there will be a summary of the responses that were typed in, along with the recording, access to the recording and the slides that will go out to everyone who participated. But there's a question about townships. Would it be the Board of Trustees and with the supervisor of a township that makes the determination of what is essential?
Yeah, so I mean, townships are a little bit, you know, different than, you know, cities or counties. They typically are a little bit smaller organized. So you may not even have, you know, department heads in a township. So in fact, that's a little bit unusual, other than having a highway commissioner. So in a township form, I'd probably have the trustees make that determination in conjunction with the supervisor and the highway commissioner. And keep in mind, there's not really a hard and fast rule as to how to go about it. So, you know, we're in a little bit of uncharted territory as to how we comply with it. But, you know, I think that's probably the best practice that we could suggest right now.
Very good. Thank you all. Thanks for staying with us and working your way through those questions. Great dialogue and discussion. Nancy is just very good at taking these recordings and getting them posted very quickly on our extension website, and that'll be part of the information that we give to you. And we'll also kind of peruse through those questions, make sure that we did take time to respond to those. If there are some links to specific sites for posters and additional information, we can try to embed that in the question responses as well. Thank you to our presenters. Excellent information, and you're getting lots of kudos in the chat space. I hope you can see that. Thanks to Kelly and the Association of County Organizations for prompting this webinar today. I think it was very helpful to everyone that was involved. We hope that you'll be able to join us for upcoming webinars that we're hosting this spring. And there will be another webinar that'll be announced for the Open Meetings Act in May. So thanks again for your interest, and have a great day, everybody.